Well, although I have the privilege of introducing this gentleman, he definitely doesn't need any introduction. He's done a lot for all of us really in Washington, D.C. Mr. David Fatuhi is a partner in Washington, D.C. office. He practices in his firm litigation department and is a member of the firm's environmental litigation and mass tort practice group. Mr. Fatuhi joined the firm after nearly 4 years of U.S. Environmental Protection Agency service, where he acted as the general counsel, principal, deputy general counsel, and deputy general counsel. The 2021 National Law Journal recognized Mr. Fatuhi as a trailblazer in environmental and energy law, and Law 360 named him a rising star. So without any further ado, Mr. Davis.
Thank you very much, Brendan. Good afternoon, everyone. Pleasure to be with you. The topic for our conversation today is the EPA Renewable Fuel Standard Program. So I'll start off with just a brief overview of the program. I take it since you all are here and are interested, you probably know some of the basics, so I won't get into too much of that, but then I'll give you a broad overview of what the agency has recently finalized and recently proposed in terms of the Renewable Fuels Standard Program, and then give you a sort of a prognostication of what I think might be on the horizon. A little bit about me. Like Brian said, I'm a partner at Gibson Dunn in the environmental group. My practice focuses on enforcement defense, investigations, as well as environmental litigation and the rulemaking process and counseling clients through agency rulemaking and challenging agency actions if the results of the rulemaking process are not what the client had hoped for. So I won't get into too much of that since we've got interesting topics to address today on the RFS. Like I said, I'll talk a little bit about recently finalized actions. There are a number of recently proposed actions that have not yet been finalized, and then give you a view of what I think is coming down the pike. Before we get into it, just in terms of the RFS program overall, just in terms of background, these are Congress promulgated the Renewable Fuel Standard Program in 2005 and amended the program in 2007. These are found in the Clean Air Act. I think at the time, the driving impetus, there were a number of stakeholders pushing for the Renewable Fuels Program, but the driving impetus, I think some saw it as a way of securing energy independence at a time when there was conflict in the Middle East and pressure to obtain more domestic sources of energy for transportation fuel. I think others in Congress advocated for it as a means of reducing greenhouse gas emissions from petroleum and liquid transportation fuels. And then certainly some were not in favor of it. But so it was promulgated in the mid-2000s. Just as a general overview, it requires the blending of biofuel into transportation fuel, both gasoline and diesel. Different types of biofuel have different requirements. So the statute lays out requirements for biomass-based diesel, for cellulosic biofuel, both gasoline, both to be blended into gasoline and diesel, advanced biofuel, and then what the statute refers to as total renewable fuel that includes within it conventional biofuel, and that's corn ethanol and more traditional conventional types of renewable fuel. The statute has tables in the statutory text that lay out annual volumes for each of these types of renewable fuel. The statute also gives EPA authority to adjust annual volumes. And it gives EPA waiver authority to waive the requirements in whole or in part if the program will result in severe economic harm, severe environmental harm, or if there is inadequate domestic supply. The standards are percentage based, so even though they're often talked about in terms of gallons, they are translated into percentages that are then applied in a particular year to determine compliance. Obligated parties here are the refiners that, or importers of transportation fuel who are obligated either to blend biofuel into their refined transportation fuel or to go out onto the trading market and buy credits. These credits are called RINs, Renewable Identification Numbers. A RIN is generated when you generate 1 gallon of biofuel. So the biofuel or the renewable fuel is generated and it has a corresponding RIN that goes with it. It's literally a number. And if you're a refiner and you buy a gallon of renewable fuel, that usually comes with a RIN, and then that's what you retire to demonstrate compliance that you did in fact blend that gallon. Or you can buy a separated RIN. So if someone else doesn't need that RIN because they've blended more than their requirement, they can go and sell that RIN to someone who does need it because maybe they're not, maybe that refiner is not able to blend it, blend the volume that they're obligated to blend. So they can go out on the market and buy a RIN and then use that for compliance. RINs can be carried over for 1 year, but after that they do expire. You can also carry over a RIN deficit if you're a refinery for a year, but eventually you do have to make up that RIN deficit by retiring RINs. RINs have codes depending on the type of biofuel they're associated with or renewable fuel. So the D3, the letter D and the number 3, that's the RIN code assigned to cellulosic biofuel. D4 is for biomass-based diesel. D5 is advanced and D6 is conventional, including corn ethanol. That is a very high-level overview. I'll get into some more details when we talk about some of the recently proposed and finalized actions EPA has taken. That's a lot of text. You don't need to read all of that, but let me just talk briefly about deadlines. So the rule I want to talk about that EPA finalized earlier this year in February dealt with compliance date extensions for demonstrating compliance under the RFS. So in the last administration, I'll just say perpetually meeting the deadlines in the statute has been a challenge for EPA since this statute was promulgated. There have been years where the agency has missed its obligation to set annual volumes by more than a year. Right now, we're in one of those periods where EPA has not yet finalized renewable volume obligations for 2021 and has not yet finalized for 2022 either. And obviously, we're well into 2022 at this point. So in recognition of that, EPA did a rulemaking to amend the timelines for compliance reporting for obligated parties. And it initially broke out small refineries. So small refineries are those that have less than 75,000 barrels of throughput a day. And we'll get to why that's important here in a minute. But small refineries got a special extension for compliance year 2019. And then all obligated parties received extensions for compliance for 2020, 2021, 2022. And like I said, EPA has already taken final action on this. The reason why that's important is because of this next slide. So like I said, EPA does annual rulemaking to set volumes under this program. There are volumes in the statute, but EPA departs from them, and there's an important reason why. If you see over here, these are the proposed volumes for 2020. EPA is has proposed to let me back up. In 2020, EPA finalized volumes for that year. Obviously, the pandemic happened, and so demand went way down. So EPA has gone back and proposed to adjust the 2020 volume down, the obligation down to meet what actually was blended. For 2021, the agency missed its deadline to promulgate those standards before that year, and so has proposed essentially what was the actual blending for 2021. I think there's some quibbles about how accurate the numbers are, but that's what the agency said it was doing. It was sort of conforming those retroactive 2021 levels to what was actually blended that year since it missed its deadline. And then for 2022, it's proposed a relatively aggressive, higher level of requirements. Now I say that these are all still lower than the statutory levels. By this point in the statute, Congress had envisioned 36 billion gallons of biofuel, and we're at 20.77 in the new EPA proposal for 2022. Most of that reduction comes from the advanced and cellulosic category. Those are just simply categories that have not matured or taken off in the way that Congress envisioned. I think from the ethanol, from the renewable fuel industry, some would say, well, that's because the standards aren't being set aggressively enough to push and create that demand. I think others would say, no, that demand simply just isn't there, and EPA's adjustment of those levels is sort of taking into account the reality of that. But by this point, Congress had envisioned something like 21 billion gallons of advanced and cellulosic. So those are adjusted way down. So like I said, EPA is doing one rulemaking to revise the 2020 volumes and to set 2021 and 2022. They are also having to deal with a court remand like I said, sometimes EPA misses its deadline. For 2016, they did a 3-year rulemaking that set volumes for 3 years. And they used one of those waivers I talked about earlier, the general waiver. And they relied on the provision about inadequate domestic supply. But in the way that they talked about it in the final rule, it was really about inadequate domestic demand, not really inadequate domestic supply. And the DC Circuit said that's not what that waiver allows you to do. It's about supply of biofuel. It's not about demand. And so you can't use that waiver to reduce your overall volume for 2016 and remanded that to the agency. The agency has decided to address that remand by doing what's called a supplemental or a special supplemental standard of 250 million gallons for 2022. You can see that at the bottom right-hand corner there in the chart. And then they've said for next year's standard, they're also going to do another 250. That equals 500 million gallons. And that's roughly what was waived in that 2016 rulemaking. So there's a sort of a special added layer of requirement on top. So public comments, came in on this proposal. As you would imagine, the renewable fuel industry was very upset about the reductions for 20 and 21 and very happy about the proposed levels for 22. Generally speaking, the refineries and the oil and gas industry was fine with the reductions for 20 and 21 and generally unhappy with the higher levels for 2022. EPA, like I said, missed its deadline by quite a bit and got sued by Growth Energy for missing its deadline, settled that case, and as part of the settlement has agreed to take final action on this proposal by June 3rd. Pretty aggressive. They've not yet sent over their proposed final rule to the White House, which is typically like the last step before it's finalized, is it's sent over to the Office of Management and Budget for interagency review. That hasn't happened yet, but they are under a settlement deadline to finalize these volumes by June 3rd. All right, I mentioned small refineries earlier. Small refineries, there's a provision in the statute that allows small refineries to submit hardship petitions. And these petitions would, if granted, exempt those refineries from the obligations of the Renewable Fuel Standard. In order to obtain one of those exemptions, you have to meet the definition of small refinery, the throughput requirement. And remember, it's small refinery, not small refiner. So Exxon or a major could own a small refinery because it's based on the throughput. And so that refinery may be eligible to get a hardship petition. It's about the size of the refinery. It's not about the size of the parent company. EPA has taken different approaches over the years to small refinery exemptions. Generally speaking, this is sort of broadly speaking, Democratic EPA administrations tend to be less favorable to these exemptions. Republican EPA administrations tend to be more favorable to granting these exemptions. Typically when EPA has granted them, biofuel interests have challenged those grants in court. These are final agency actions that are reviewable if you can establish that you have standing to challenge them. The statute has some interesting language about this. It says that refineries can apply at any time for these provisions or for these exemptions. But it also talks about them as extensions. There are small refinery exemptions, but the way the statute talks about them is everyone got a blanket exemption at the beginning of this program, and then EPA acting on a petition can extend them. So there's a little bit of tension there about what it means. Do you have, the question came up in litigation. If I had, if I'm a small refinery and I haven't gotten one of these every single year, am I eligible to get one in the future? Because you're not really extending something if there's a broken chain, right? If I missed a few years because I didn't have hardship, and now I'm saying I have hardship again, am I eligible for the extension or not? So that's the question that went up to the Supreme Court in this case, Polyfrontier against Renewable Fuels Association, that was decided last year. And the court said in that case, you do not need an unbroken string of exemptions to be eligible for future exemptions. They sort of read the word extension broadly, and you had kind of an interesting alignment where you had the 6 male justices in the majority and the 3 female justices in dissent. It's sort of a coincidence. I don't really know what that, what import that is, but Justice Barrett joined Sotomayor and Kagan in dissent in that case. And Justice Breyer joined the majority. So, there was a cloud over this exemption program based on the lower court decision coming out of the 10th Circuit that said, no, it has to be this unbroken chain. And if you miss a year, you can never get an exemption ever again. The court said, no, that's not right. The issue now is, okay, EPA now has that case to deal with. But the question is, well, how do you demonstrate hardship? And the agency has taken a new approach in a proposal that it issued in December. The way this process typically works is that the refinery submits an application. The application or the petition gets sent to the Department of Energy for an assessment, a score, and that is sent to EPA. EPA considers the score along with the factors that the statute calls out for it to consider, and then issues a decision to grant or deny the exemption. EPA issued a proposal in December that said, we're going to propose as a blanket, not sort of case by case, but all pending small refinery exemptions, we're going to propose to deny them. And the theory that they based that on was this concept called the RIN cost pass-through. So EPA has adopted this view that all refineries, not just small refineries, but all refineries recover 100% of their compliance costs from the RFS program by passing those costs downstream and eventually to the consumer. The refinery industry says that's totally wrong. They've got studies that back up the theory that no, they have to bear some of those compliance costs directly, that they're not all passed through. The renewable fuel industry says absolutely not. They are entirely passed through. You're not actually bearing any of the costs yourself. And EPA has now agreed with that in its proposal. And so there are 60 or so pending small refinery exemption petitions that the agency has proposed to deny. Has not yet taken final action on that. In terms of the public comments, industry is split. You can see the majors support no exemptions. The sort of AFPM, came out against it. There's another issue that's probably, we may actually have some news here, like similar to this morning. EPA also has this other thorny issue of previously granted small refinery exemptions. So in 2019, EPA granted about 31 small refinery exemptions. The biofuel industry sued and challenged those grants. The Biden administration went into the DC Circuit on the change of administration and said, we no longer want to defend these grants. We want to take another look at them. So court, put this case on hold, send these back to us for reconsideration. The court said, fine, but we're going to put you on a clock and said, you have to make a decision by 120 days from December 8th, the date of the order. That's today. So there may be news that EPA has, if they're going to take a position consistent with their proposal for the more recent ones, they're going to deny these. but there's the thorny issue of reliance interests on, taking away exemptions that have been relied upon now for almost 3 years, and how they're going to balance that. So that's the question mark with the 2018 SREs.
Do you see the gas prices and things now making it less favorable?
I think, yeah, let's see, we'll go to that here. So it's like you read my mind. Yeah, this chart here shows you RIN prices by those different types of RINs. So I said D3, 4, 5, and 6. That's the colors that correspond there. D6, like I said, is conventional, so that's the most common. This starts in 2019, this chart, and goes through about February of this year. You see, here's 2021, right? You see relatively low levels and relatively low volatility through much of the last 2 years, including during the sort of the beginning of the pandemic. And then prices start to slowly tick up, and then you see, upon sort of the, change in administration, rising energy prices, rising demand, you see volatility increase, and you see prices increase, and that's substantial. I mean, this scale over here is $1 per line here, so it's a significant increase in RIN costs. You don't have to be an obligated party to trade RINs. So, I think some obligated parties think that there's arbitrage and, people sort of gaming the system that have nothing to do with renewable fuels or refining, just wanting to play the market. And it's a spot market and it's sort of over the counter. There's no like publicly available, instantly knowable price. It's sort of, peer-to-peer type transactions that then have to be submitted to EPA within a certain period of time. To be recorded. So I think there's some, there's definitely concern among the refinery industry that there's manipulation. Obviously, there's concern that the agency is missing deadlines and creating uncertainty. That was a concern when I was at the agency. It's still a concern now. And obviously now with the Biden administration taking a more favorable approach to the renewable fuel industry, it's pushing those prices, it's pushing those RIN prices higher. Envisioning that the levels will be set progressively higher. And you've got rising prices across the board. At the same time, you've got rising demand for transportation fuel. And like I said, because it's a percentage standard, it sort of rises with the demand. It's not as though demand can overcome the rise in the standard. So it is a volatile time in the RIN market, and I think EPA, no matter under what administration, wants the RIN market to be calm. I think that's generally what they would say that they want. But at the moment, by sort of by some of the actions that have been proposed, and we'll talk about a couple more here in a minute. The market seems to be you see some leveling off, but volatility is still higher than it's been traditionally. And you are seeing as well some refiners, especially in the West, in the Mountain West, start converting to biodiesel as a way to, basically generate RINs in a more cost-effective way that they can use elsewhere across their other facilities. So like I said, this new administration is more sympathetic to the concerns of the renewable fuel industry, but not entirely. And I'll get into a couple of examples because you've got a split among the environmental NGO community about whether the renewable fuels program is valuable or not, especially from the perspective of climate change and endangered species and land use. So, like I mentioned, the agency now fully agrees with this RIN cost pass-through theory. And if you look at the proposed denial decision document for the small refinery exemptions, they lay that out in lots of detail about the economic analysis they're relying on. Like I mentioned, stakeholders with diverse views. This doesn't break down along partisan lines. Typically, it's much more regional. So you've got the Democratic governor of Pennsylvania pushing, advocating for refineries. You've got, the Republican governor of Iowa advocating for renewable fuel interests. It's not as partisan as some other issues at EPA. It's much more regional. Bipartisan letters from Congress get sent to the agency on both sides of this issue frequently. EPA did a study after it was sued by NRDC called the anti-backsliding study under the Clean Air Act. There's a provision that requires this. EPA never performed this study and ultimately entered into a settlement agreement to do one. NRDC was taking the position that the RFS program results in adverse air pollution impacts. The agency did a study that said there are some negative impacts from the program, but none that need to be addressed due to Tier 3 standards and other existing requirements. So it was sort of a split the baby type of decision that, you know, the report itself was not very favorable to the renewable fuel interests, but the sort of the outcome was basically resulted in no additional requirements. And then this last point, ESA consultation. So the agency had traditionally taken the view that the requirement under the Endangered Species Act for it to engage in a consultation with the Fish and Wildlife Service and, you know, sometimes the National Marine Fisheries Service, but in this case, it's really Fish and Wildlife, was not required when it would set annual volumes because the impacts on species were too attenuated. And when the DC Circuit reviewed a recent annual volume rule, it upheld the entirety of the rule except for this finding and sent this back to the agency and said, no, these annual rules do require ESA consultation because of some of the things I mentioned earlier. So dedication of land use to growing corn for ethanol, the impact of that water usage, pesticide application on not just land use, but also endangered species and critical habitat, that those are linked closely enough to the agency action and the line between them is specific enough that the agency needs to consult with the expert services at Fish and Wildlife before it can finalize annual rules. So this could be kind of the sleeping dog that hasn't barked yet, because, you know, depending on how those impacts are assessed, you know, the whole concept of ESA consultation is the agency should be within its statutory discretion taking the outcome of that ESA consultation into consideration when it finalizes its regulatory action. So if the agency has no discretion, if the statute says consider these three factors and only these three factors, then there's no room for ESA consultation. But if the statute's more open-ended, which the court here says it is, then EPA can consider the outcome of the ESA consultation when setting volumes. And so we'll see how it deals with that. And it's going to have to deal with that pretty soon. So as I mentioned, the statute has, unlike almost any other statute that I'm aware of, there's literally volumes and charts in the statutory text where Congress set volumes for the first 15, 17 years of this program. Those end in 2022. There's no further volumes after 2022. There's just a list of statutory factors that the administrator of the EPA, in coordination with, right, the Secretary of Energy and the Secretary of Agriculture, based on a review of the implementation of the program over the last 18 years, and an analysis of these 6, you know, very specific factors, is supposed to just sort of write on a white piece of paper the new volumes for the program moving forward without kind of those statutory benchmarks to depart up or down from. Right, those expire. So now we've got a blank sheet of paper and just these factors. So this is what the agency is supposed to consider when promulgating what sort of is colloquially called the SET rule, which has not yet been proposed, but the government has said they plan to propose it in May. We'll see if they hit that. But so they're supposed to consider, you know, they're supposed to consult with DOE and USDA. The EPA is supposed to consider the implementation of the program, and they're supposed to look at impact of renewable fuel production on the environment, including climate change, including wetlands, including habitat. That's the ESA issue I talked about earlier. Impact of renewable fuels on energy security, on the expected annual rate of future commercial production of fuels. So sort of that demand side supply side consideration. Impact of renewable fuels on infrastructure, including deliverability of materials, goods, impact of the use of renewable fuels on the cost to consumers. So this is where the agency, if they're going to stick to this theory of green cost pass-through, in that sort of theory, they say, yes, these costs are passed through, but the costs aren't that high. And so the end consumer really isn't paying a markedly higher amount for fuel. It's sort of nominal. So they'll have to look at that again here for this rule. And then the impact of renewable fuels on other factors, including job creation, price of agricultural commodities, rural economic development, and food prices. So this is very prescriptive. It doesn't lay out the outcome, but this is an immense amount of very specific factors that if the agency fails to analyze or consider, that would be procedural error right there in a challenge to this rulemaking. So this is a massive undertaking to conduct this type of analysis and set volumes where you fully explain how you considered and weighed all these factors. I mean, how do you weigh factors like this against each other, right? It's very subjective, but as with all rulemaking, the agency has to adequately explain where it's coming out and where it could have gone but chose not to. It's gotta lay all that out and take public comment. So this is a significant undertaking for the agency that they're working on right now in order to set deadlines for the 2023 compliance year, because that's when this first needs to happen. They're already a little bit behind for that. You would have wanted to have these finalized by like April or May of this year. So they are a little behind. All right. Just briefly, and then we can take questions. I mentioned the Esa Consultation. I kind of already went over that. They remanded the 2018 annual volumetric rule because they said the agency violated the ESA for failing to determine whether that rule affected species or critical habitat. So EPA has not yet taken action on that remand yet. Point of obligation, that's simply putting the obligation requirement on refineries. That's not in the statute. That's an EPA decision. Almost every year when the annual volume rule is challenged in court, which it inevitably is by both sides of this issue, the refinery interest or some refinery interest raised this point of obligation. Their view is that EPA has a duty every year to consider whether the point of obligation should stay on refineries or should be moved. That's how they read the statute. Up to now, courts have held no, it's not an annual obligation. EPA can rely on its past determination that setting that obligation point on refineries is appropriate. So we'll see, right? I mean, the agency has to, potentially deal with that issue. There are petitions pending before the agency by refineries to change the point of obligation. This was raised in the challenge to the 2020 rule. As you may remember from a few minutes ago, EPA is adjusting those 2020 volumes due to the reduction in usage during the pandemic. And so EPA sought to put that case challenging the 2020 rule in abeyance. And the refinery challenger said, well, that's fine, put the volume part of that challenge in abeyance, but let us continue litigating these other issues like the point of obligation. And the court said no. So they just put the whole case in abeyance. That it's not, you're probably not going to get another decision on point of obligation, at least in the near term. It might be more of a medium term issue. And then very, very lastly here, E15 year round. So this is a somewhat complicated issue, but the biofuel and renewable fuel industry has been pushing for a long time for EPA to change its regulations or at least grant a exception for E15 during the summer driving season. And the exception is from its RVP, the rebate pressure requirements. The agency, when I was at EPA, did a rulemaking that would have allowed E15 year round. The DC Circuit vacated that rule and said that it exceeded the Clean Air Act statutory authority that the agency relied upon to set that rule. So during the summer driving season, due to the RVP, you're back to E10 only. And there's been continued pressure on the White House and EPA in this administration to find a workaround that would allow for E15 blending year round. EPA has signaled it appears open to a state-by-state approach. There's a provision in the statute that allows for states to make a RVP determination and submit that to EPA for approval, but the state needs to move first. So there's a bit of waiting for the other, the federal government and certain states are kind of waiting for the other to make the first move here. There's also pressure for EPA to do a rulemaking to just change the vapor pressure regulations overall, just so that it can allow E15 for the summer driving season. So those are just some other RFS related issues. Let's see, we've got about 5 minutes for questions, if anyone has any. Yes.
I do, and